Welcome to students.Com, a learning portal for company secretary students. Presentation on Interpretation of Statutes. Part 1. Interpretation of statute has been a part of company secretary curriculum since the course started. It has been one of the tricky topics to study for students. In the core legal education, the interpretation of statutes is a separate and very important subject. For company secretaries, it's important to have some basic idea about the interpretations. Accordingly, some basic aspects of the various topics of interpretation of statute have been included in the CS curriculum. Similarly, in this presentation, we would try to cover the basic rules on the topic. We will also try to quote the examples for better understanding. If you have any questions, please put that as comment. First, we understand the meaning of interpretation of statutes. The meaning of word interpretation is a mental representation of the meaning or significance of something. So, interpretation is not limited to the meaning of something, but it also includes a mental representation to make the application of that word or term. The statute means the law passed by a legislature or legislative body. In India, laws are made by various legislative bodies, such as our Parliament or our state legislative councils. Under the Constitution, these are law-making bodies. These law-making bodies draw their powers from Constitution. For academic purpose, we have various definitions of the term statutes. Some say, it's a will of legislature, or the intention of legislature that comes in the form of a written act or a written statute. Indian legal system is based on the legal system of United Kingdom. Therefore, some of the basic principles of interpretation are based on the principles followed in United Kingdom. Indian courts, in various cases, have upheld these principles. The word statute is a synonym of the word law. The Indian Constitution does not use word statute. It uses the word law. And the definition is given in Article 13, which is, law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage, having in the territory of India the force of law. So, it's an inclusive and broad definition. And it includes the regulations, customs, etc., if they are under the force of law. Therefore, strictly in Indian context, the interpretation of statute should mean the interpretation of law. Let's take a look on the different classes of statutes for the purpose of interpretation. The first is codifying. Codifying is a process in which the law-making authority converts an unwritten law into a written law. Unwritten law basically denotes to a custom or a practice which is already followed by the people. Legislature merely passes such custom or practice as a written law and gives it to legal recognition in that territory. The primary condition of codifying is that there is no written law already in place on the same subject matter, and an unwritten law is already in place. Lawmakers are only converting an unwritten law into a written law. The second is declaratory. Declaratory law is actually not a law. It is just an explanation over the existing law. In this case, the authority is not actually making any new law, but only providing an explanation or clarification over the existing law. We see lot of clarifications on various laws, such as Ministry of Corporate Affairs keep issuing clarifications on the Companies Act. Same could be part of declaratory statute. The third is remedial. The word remedial means to rectify or improve something. If there is a flaw or shortcoming in the existing law, and by making an amendment, that flaw is being corrected, that amendment is called the remedial law. Sometime, judges sitting in the court can also take a bit different interpretation, with an objective to correct that flaw or shortcoming in the written law. But that may not be statutory law. The next is amending. It's very simple to understand amending. When law is altered or modified, the alteration could be for improvement, or to deal with social changes, or to deal with different requirements. The next is consolidating. When various statutes on same subject matter are clubbed into one law, it's called consolidation. For example, the Goods and Services Act, which is currently under consideration, will consolidate certain existing indirect tax laws. Consolidation may add or amend in the existing statutes also. Then enabling. Enabling law is something which removes some restriction and allows some activity. For example, earlier, foreign investment was not allowed in India. Later restrictions were removed and same is allowed now. The next is disabling or restraining. This is when some restriction is put across by the law. For example, civil laws in India enables the courts to put restrictions on transfer or alienation of the property in certain cases. The last is penal. Penal statute provides the penalty, like Indian Penal Code. Now, we discuss the need and object of the interpretation. The basic objective of interpretation is to understand the language given in the statute, and to apply the same in real-life situation. The idea is to give it a true meaning and application to real-life scenario. Although it looks simple to read the language, until we have to apply the same in real life. And it becomes most difficult in the cases where language given in law is not very clear. So, the correct interpretation becomes crucial. Different books and judicial case laws have discussed the objective of interpretation of statutes. We would discuss some of them over here. Maxwell Interpretation of Statute is a notable book on interpretation. And, as per this book, the objective of all interpretation of statutes is to determine what intention is conveyed, either expressly or impliedly, by the language used. So far is it necessary for determining whether the particular case, or the state of facts presented to the interpreter, falls within it. With this language given in Maxwell, the objective seems to determine what intention is conveyed by the language given in statute. Also, such intention may be express or implied. So, the interpreter should also take the implied meaning into consideration. Also, such interpretation should be applied, so far it's necessary to determine whether particular case or facts falls within the ambit of that intention. But the objective given in Maxwell seems little narrow. On the objective of interpretation, important observations were made in case of Seaford Court Estate versus Asher. Some of the important observations are: it's not possible for human to imagine all the possible circumstances while framing the law, and to provide the same, free from ambiguity. Then, the English language is not a mathematical formula that it can provide single and clear interpretation in all the cases. Because, if the language becomes mathematics, it would restrict the scope of expression, and the literature would be poorer. Then, when the effect appears in the law, the judge must work on the constructive task of finding the intention of Parliament, and this should be done not only with the language of statute, but in consideration of various other factors. So, the observations made in Seaford Court Estate versus Asher do accept that it's impossible for the person drafting the law to imagine all the scenarios. It also adds that, in case of ambiguity, the judge cannot simply fold the hands and blame the draftsman who has drafted the law. Alternatively, the judge is expected to do some constructive task to determine the real intention of the Parliament. Now, we come to the rules of interpretation. Here in this presentation, we would discuss various rules of interpretation. These rules are basic principles which should be used while interpreting the law. These rules are actually not part of the law, but they got their recognition over a period of time under various court judgments. They should be used merely as guidelines to read and interpret the law. So, the first rule is literal construction. This is also called as the golden rule of interpretation. Literal construction means the language of statute should be read and interpreted as it's written. Means, while interpreting the law, we should take the very basic, natural, and ordinary meaning of the language written. Therefore, as per this rule, the word, phrases and sentences of a statute should be understood as per their natural, ordinary, popular, and grammatical meaning. This is the easiest way to read the law. Take the meaning, what is most natural, ordinary and popular. But, one cannot apply the literal interpretation if that natural or ordinary construction leads to some kind of absurdity, or the contents or object of the statute suggests a different meaning. In those cases, one has to look for another interpretation, which is aligned or in coordination with the subject matter of that statute. Basically, if the statute's language is clear and aligned with the subject matter of that statute, there is no need to go for any other interpretation. Certain points to keep in mind while applying the literal construction. In English language, same words, sentences or language may have multiple meanings. Therefore, when we say ordinary meaning, one should take the ordinary meaning as applied to the subject matter of that statute. The main principle involved with the literal construction is to read the language as it is. Nothing is to be added or taken away from the language in the statute, unless there is an adequate ground to justify that the legislature or law-making authority intended something which is left omitted. Also, the literal construction of a particular part of statute cannot be done in a way that it makes some other part or some other provision of that statute redundant or inapplicable. Other sub-rules of literal construction. Every word in the law should be given a meaning. This is on the presumption that, in any written law, no word is unnecessarily used. Similarly, if some word not used in the statute, one should not straightway assume the omission and take the meaning of that word. Means, if some word is not part of the statute, no need to add meaning of that word while interpreting. The next rule is the Mischief rule, or Heydon's rule. This is the most important rule of interpretation, and also frequently asked in the exams. It was pronounced in Heydon's case in 1584. Therefore, also known as the Heydon's rule of interpretation. The general meaning of word mischief is an annoying behavior, which can cause trouble or harm. To simply understand this rule, please remember that there was a mischief, or defect, in the law, which was later corrected by the Parliament. It happens sometimes that the written law does not cover some particular subject matter, or the language may need some refinements to remove the defect, or there may be more clarity required on the existing language of law. And considering all that, the legislature or Parliament may come out either with a new law on the subject matter or an amendment in the existing law. Under the Mischief rule, we interpret the new law or amendment comparing with the old law. We would look for the mischief or defect in the old law, and the remedy or correction done by the Parliament in the form of new law or amendment. Theoretically, the Mischief rule puts 4 important questions before the judge for interpretation of law. Those 4 questions are: what was the common law before Parliament making the new act or amendment? Over here, the common law means a law which was prevailing before the correction. Then, what was the mischief or defect existing in the common law before making the new law or amendment? The idea is to find out the mischief or defect beforehand, so that we can make an appropriate interpretation of the new law or amendment. Then, what remedy the Parliament has provided to cure that mischief or defect in the form of new law or amendment. And the last, to find out the true reason of that remedy. Therefore, if there are multiple interpretations or multiple meanings coming out from the written law, the judge can apply this rule and determine the appropriate interpretation. It becomes easier to interpret the law if you know the earlier defect and cure provided by the Parliament, and the reason of that cure. The rule aims that the judge should adopt the construction or interpretation which suppresses the mischief or defect and advances towards the remedy. But, as a caution, please remember that this construction cannot be done by ignoring the plain natural reading of that law, or by disregarding the context of that law. So, if plain reading is sufficient enough to reach at an interpretation, there is no need to apply Mischief rule or we say Heydon's rule. Honorable Supreme Court in one of the case, conveyed the view as the Heydon's rule of interpretation should be applicable only when the word in the question are ambiguous and are capable to give more than one meaning. So, the broad principle behind Heydon's rule should be: after the words or language in the law has been constructed or interpreted in their natural context, and it is found that the language is capable to have only one meaning, the Heydon's rule will cease to have effect or control, and plain meaning rule will take effect. The next rule is reasonable construction, for which the Latin maxim is ut res magus velit quam perit. In real life also, we look for a sense, or reasonableness, in any understanding we have. This rule of interpretation also talks about the same, as we discussed earlier, in rule of literal interpretation, that the words and sentences should be taken in their natural and ordinary meaning. But, if the ordinary meaning does not mean a fair and reasonable construction, one has to switch to the rule of reasonable construction. According to this rule, the word of a statute, or law, should be construed to give a sensible meaning, the meaning which is reasonable and logical. Ut res magus velit quam perit is a Latin term, referring to a legal concept, to construct a law in a way to make sense, rather than to void it. This rule advocates that the law cannot be interpreted at its disjoints with the common sense. Laws are also drafted by the human beings. If the dictionary meaning seems to defeat the purpose of legislature, and creating a mischief or defect, the court can shift its interpretation to some meaning which suppresses the mischief, or suppresses the defect, and encourages the cure, or remedy. So the punchline of this rule of interpretation is: the courts can depart, or shift, from the dictionary meaning of a word, and give it a meaning which will advance the remedy, and suppress the mischief. So remember, the rule which advances the remedy, and suppresses the mischief, is the rule of reasonable construction. The Honorable Supreme Court, in a leading case, made the observation, with regard to rule of reasonable construction. In this regard, the apex court said, it is only when the language of a statute, in the ordinary meaning and grammatical construction, leads to a manifest contradiction of the apparent purpose of enactment, or to some inconvenience, or absurdity or hardship of injustice, presumably not intended, a construction may be put upon it, which modifies the meaning of words, and even structure of sentence. Let's have a recap of the rule. So, when the ordinary meaning and grammatical construction leads to a contradiction, or such ordinary meaning leads to some inconvenience or absurdity, over here, absurdity means silliness, or such ordinary meaning leads to hardship of injustice, means that literal or ordinary meaning, or grammatical construction, creating a hardship of injustice. And this contradiction, or inconvenience, or absurdity, or this hardship of injustice, is presumably not intended by the Parliament. In the above scenario, a construction may be made, which modifies the meaning of the words, and even structure of sentence given in the statute. So, judge's job is not to just interpret the statute with its natural or ordinary meaning, but to take it to a reasonable construction, according to the purpose, policy, or spirit of the statute. Relating to the same rule, let's have some more flavor of the Latin terms. The first is literal legis, which means to go by the words of the law in ascertaining the law, or we say to take literal construction. Another term is ratio legis, which means reasoning of law. And if we try to adjoin these Latin terms in our rule of reasonable construction, we would say, if the court considers that the literal legis is not clear, it must interpret the law according to ratio legis. Now, we discuss the rule of harmonious construction. The word harmonious means suitable and fitting, or we say, staying in harmony. Many times, it happens that the two provisions of the same law provides inconsistent interpretations, and it becomes difficult for the courts to choose one of them. Then, the rule of harmonious construction comes into play. The basic premise of this rule is the statute should be read as a whole. Means, if you are interpreting some provision, you should construct the meaning with the reference of all other provisions of that statute, so as to make a consistent construction. Therefore, one provision of the statute must be interpreted in a way that it retains the effect of the other provisions of that statute. There are certain important case laws where rule of harmonious construction got the recognition under the Indian judicial system. It is suggested to read them to have more on this rule. The next is Ejusdem Generis, is another important rule of interpretation. It deals with a narrow or a wide meaning of a word. But before we discuss this rule, let's see how the meaning of a word becomes wide or narrow. For example, the word books. The scope of the word books would covers every book in this world. But if we add one more word before the word books, say mathematics, then the combined scope of both the words would narrow down to cover only mathematics books. Similarly, the word company. It may mean to include all the companies. But if we add the word private, then the combined meaning would only include private companies. The rule of Ejusdem Generis also works on the similar lines. As per this rule, under any law, if any general word is following the specific word, then the meaning of such general word should have specific meaning relating to that specific prefixed word. In our first example, general word was books. Specific word was mathematics. So, if the general word is following, or coming after the specific word, the meaning of that general word should be confined, or restricted, with reference to that specific prefixed word. Therefore, in our example, the moment we prefix the word mathematics, the interpretation of the word books became restricted to mathematics books. The literal meaning of Ejusdem Generis is of the same kind or species. While doing the interpretation, when we try to cover certain specific kind of things or certain specific kind of species, then the rule of Ejusdem Generis comes into picture. This is one of the rule where the general word in the statute is not interpreted in the general sense, rather taken into a specific sense due to a prefix. However, the rule should be applied carefully, as it provides a divergence from the general meaning of that word to a very narrowed down meaning. In this first part of the presentation, we discussed the basics of interpretation. We also discussed certain important rules. In the next part, we would discuss some more rules of interpretation and other aids. Till then, keep watching students.Com. If you liked the presentation, please click on the like button below the video screen. Thank you.